The judge overseeing Sean Combs' criminal case in New York has just ruled on whether or not the rapper's rights were violated when his materials were searched and photographed while in lockup. We're going to go over the full decision and what impact this is going to have on Sean Combs' criminal trial. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Okay, so we've been waiting for this. Almost kind of forgot about it. There's been so much going on in the Sean Combs case. But the judge overseeing Sean Combs' criminal case out in New York, this federal case, has just decided whether or not Combs' rights were violated when there was a sweep by federal authorities at the detention center where Combs is currently being housed. Big issue that we've been focusing on, right? Why? Because the ramifications could be huge. If prosecutors, generally speaking, if prosecutors engaged in a form of misconduct that violates a defendant's rights, they might have to be recused from the case. The evidence could be excluded from trial. Maybe if something is really egregious or bad, the case gets dismissed. So I want to go through this order from Judge Arun Subramanian of the Southern District of New York. It's really fascinating. So again, Combs is facing federal racketeering, sex trafficking, and prostitution charges with a trial scheduled for May. Now, this is how the order begins. In connection with the Bureau of Prisons' October 28, 2024 to November 1, 2024 sweep of the Metropolitan Detention Center, the MDC, a BOP investigator, Investigator 1, photographed 19 pages of Combs' notes and sent them to the government's filter team. The filter team consists of AUSAs, these are Assistant United States Attorneys, who aren't involved in the investigation or prosecution of this case. The filter team redacted the notes and sent them to the case team. The case team consists of the agents and AUSAs investigating and prosecuting Combs. So let me start there. So yes, there was a raid at the MDC, the Metropolitan Detention Center, where currently Sean Combs is being locked up. Now, the government has always indicated that this raid was pre-planned, and it wasn't specifically about Sean Combs, whose unit was searched. Now, Combs' team has had a different take, which we'll get into a little bit more, but basically the idea was that this was a pretext to search Sean Combs' unit. But the idea here is there was a raid to search for contraband. This is a detention center that has been plagued with violence and drugs and weapons. Okay, so this raid, this sweep, it happens. And this investigator, Investigator 1, apparently took photos of 19 pages of Sean Combs' notes and sent them to a filter team. Now, a filter team is supposed to be an independent, third-party team not connected to the prosecutors that are involved in Combs' actual criminal case. They go through the documents and they make sure there's not anything in there that's attorney-client or work product privileged, okay? So the order continues from Judge Subramanian. In November, the government included some of what it received from the filter team in its opposition to Combs' bail application, and Combs objected, arguing that those notes contained privileged information and were obtained in violation of Combs' constitutional rights. The court held an emergency hearing at which the government indicated that it would not rely on the notes in opposing the bail application. The court ordered the case team to get rid of the notes in its possession, which it did. Now, let me break that one down for you. So the prosecutors, they did initially want to use those notes in arguing that Combs should be denied bail. Why? Because they seem to indicate that those notes suggest Combs was improperly contacting and paying off a witness in the case. Yeah, they say this will show it. But yes, Judge Subramanian, in the end, ordered that those 19 pages be destroyed and that the government did not and could not use those notes in their argument for bail, but for Sean Combs, it didn't matter. He was denied bail nonetheless. By the way, we talk about some pretty scary stories on here. We're always trying to let you know about what's going on in the world. That's why we also partner with sponsors who can maybe offer you up some protection, and that includes Delete Me. So did you know that your personal data is being harvested and sold online by data brokers? Yeah, anyone can buy your personal information. And when that happens, you are at risk for a whole host of things. Identity theft, becoming a target of phishing scams. That is why I'm so happy to tell you about our sponsor, Delete Me. Delete Me helps keep your personal information private. Delete Me found dozens of data brokers with my information. It was on a whole bunch of listings, but they were able to remove it. And also, Delete Me will keep monitoring the sites for you so your information doesn't find its way back on there after the first removal. And honestly, using Delete Me, it has given me some peace of mind about my family too, because if someone buys your data via a data broker, they can see information about your relatives alternatives too. So right now you can get 20% off Delete Me and protect your personal data when you go to joindeleteme.com/sidebar and use promo code sidebar at checkout. The order from Subramanian continues. Combs has now filed a motion for an evidentiary hearing and other relief, arguing that the seizure of his notes violated the Fourth Amendment and that the government intentionally obtained his privileged communications in violation of the Sixth Amendment. So we'll start with the Fourth Amendment, which protects against unreasonable searches and seizures. And the argument would be this applies to detainees. They have a level of privacy too, that even in a jail or a detention center or prison, again, they have rights against warrantless searches unless there's some sort of legitimate security issue. The Sixth Amendment, which includes right to counsel, the idea here is that by taking notes that allegedly contained communications with attorneys and work product material, this unconstitutionally interferes with the attorney-client relationship. It invades the defense camp and may violate Combs' ability to defend himself. The argument is the government interfering can violate a defendant's right to effective assistance of counsel. So Subramanian writes in his order, quote, in response to the motion, the government argues that there were no violations, but also that it won't offer as evidence the notes or any fruits of the notes. In a December 20th, 2024 ex parte letter, meaning it was filed only by the prosecution for the judge, but Subramanian acknowledges that the contents of which were later shared with the defense, the government outlined certain investigative steps taken upon receiving the notes, but it represented that it will not offer the evidence obtained pursuant to these investigative steps in the prosecution of the defendant, and that it intends to produce the evidence obtained from these steps to the defendant to the extent it has not already. Okay, so the prosecution is basically saying, we're not using what we found in this unit, and we turned over what we found to the defense. Now let's get into Subramanian addressing each of those defense arguments. Quote, the first question is whether Investigator 1 violated Combs' Fourth Amendment rights when he searched Combs' cell and photographed the notes. The usual remedy for a Fourth Amendment violation is the suppression of evidence, meaning it won't come into trial. But Subramanian says all of this is moot because it doesn't matter anymore. It doesn't matter because the prosecution agreed not to use the notes in their case or anything that came from the notes, fruit of the poisonous tree, or any evidence that came from an investigation based on the notes. They will not use any of this in their case in chief. But Subramanian did advise that if the government later tries to use evidence that it promised not to use, then Combs' defense attorneys can make an objection and they can argue a Fourth Amendment violation. But for right now, basically, nothing more to do. So now you move on to the alleged Sixth Amendment violations. Subramanian writes, relief may be warranted under the Sixth Amendment where the government intentionally seeks to obtain a defendant's privileged communications to interfere with the attorney-client relationship. There are two questions that matter here. Did the government intentionally invade Combs' relationship with his counsel? If so, has Combs been prejudiced? Meaning, was the case now tainted against Combs in some way, right? Well, Subramanian writes, under the circumstances here, assuming without concluding that a portion of the unredacted notes was privileged, there are no grounds for relief. Okay, why? Well, first, Judge Subramanian concludes that the government didn't intentionally invade Combs' privilege. Quote, it is undisputed that the photographed notepads were separate and apart from a manila folder that was clearly marked legal. Investigator 1 didn't search that folder. While Combs initially told the court that the photographed notepads were marked legal as well, the defense retreated from this position when confusion developed over when the handwritten legal labels had been added to the notepads. That's true, I remember that. We covered this court hearing live on Law&Crime's YouTube channel, and as we were getting updates from the court, since there were no cameras, I remember one of the updates was that Subramanian seemed kind of miffed at the defense for not knowing what and when something was marked as legal, and he was kind of scolding the defense about that. Don't make any, statements to the court that aren't accurate. And it makes sense that he would have this concern because, of course, the issue would be if something was marked legal after the sweep at the MDC to make it look like privileged materials were searched or photographed, right? That is the problem here. When they were marked legal, what was marked legal. So Subramanian once again calls out the defense here. And he continues in his order, quote, "Second, Investigator 1 sent the photographs he took to the filter team, not the case team, to review for any privileged information. It may be that the filter team's privilege determinations were inaccurate, but nothing indicates any intent to intrude on Combs' privilege. Third, the court notes the high level and generic nature of the notes, and the fact that case-related commentary from Combs was often mixed in with clearly unprivileged information, like reminders about a family member's birthday and inspirational mantras. In other words, Subramanian explains that the defense had to later explain how specific notes in Combs' unit were related to the case and how they were related to defense strategy, because on its face, without context, it wasn't really clear what those notes were about. Meaning there's no grounds to conclude that this was an intentional intrusion into Combs' privilege when on its face you didn't even know what these notes were about. It wasn't clear that it was attorney-client or work product privilege material. Finally, Subramanian writes, the government promptly turned the photographs over to Combs, which further weighs against any inference of intentional malfeasance. This episode illustrates why the filter team should communicate with the defense before giving Combs' case-related materials to the case team, but it does not bear the hallmarks of intentional intrusion or conduct that is manifestly and avowedly corrupt. So this seems to suggest that the filter team, they may have made some mistakes here. They made some mistakes on what was privileged. They made some mistakes in not alerting Sean Combs' defense team before handing things over to the prosecutors. This is not enough to say that Sean Combs' rights were violated under the Sixth Amendment. However, there is another argument that Subramanian addresses. The argument put forward by the defense is that Investigator 1, who apparently searched Combs' notes, took the photographs of them, that he is actually an agent of the prosecutors, that he was working with them, that he was feeding them jailhouse communications, that he was acting like a, quote, informant in the defense camp, that he has been investigating Sean Combs at their direction to get more evidence for their case. You could see why that would be a big problem, right? I actually want to read you some of what the defense argued in a prior filing. Quote, while the government says it didn't specifically direct Investigator 1 to search Mr. Combs' notes in advance of the raid, its conduct after he alerted them to the material suggests this could simply be part of an effort to distance the prosecutors from conduct they knew they couldn't legally participate in. And then the defense actually goes back to the transcript from a court hearing where Judge Subramanian asked whether it's possible Investigator 1, quote, thought of himself as an agent of the prosecution team. So the defense continued in their filing, was there a tacit understanding that he should do what he could to help the government develop evidence against Mr. Combs at any opportunity? Who is Investigator 1 and whose instructions was he following? The court should order the government to produce Investigator 1's communications with the prosecutors, take his testimony to fully understand what he was thinking during the search, and explore whether the BOP, the Bureau of Prisons, that sweep served as pretext for his targeted search of Mr. Combs' materials. Now, Judge Subramanian has a response to that as well in his order. Quote, the court ordered both the case team and Investigator 1 to furnish sworn affidavits explaining the chain of events surrounding the MDC sweep and ordered the production of all written communications between the case team and Investigator 1 for an in-camera review. A careful review of these documents confirms that there has been no intentional interference with Combs' attorney-client relationship. Affidavits by Christy Slavic, a prosecutor on the case team, and Investigator 1 give consistent narratives. What those narratives are, we don't know. It's actually blacked out. It's redacted in the judge's order. But the main idea, there was nothing nefarious. There was nothing necessarily intentionally improper going on here. But Judge Subramanian continues. And what he tries to do next is he tries to put water on the claim that the raid was a pretext just to search Combs' stuff and get evidence on him for the criminal case. Because Subramanian writes in his order, 2 supervisors at the U.S. Attorney's Office were aware that the BOP planned to search Combs' unit during the security-motivated sweep, and they supported searching this unit despite delays in searching other units. Slavic's affidavit indicates that there was no direction from any SDNY personnel that Combs be under special scrutiny during the sweep of his unit. And no one at the U.S. Attorney's Office, including the case team, knew that Investigator 1 was part of the MDC sweep until after it was over. The case team was informed of Investigator 1's role following the sweep and promptly asked for the photograph notes to be sent to the filter team. Written communications between the case team and Investigator 1, which the court reviewed in camera, tell the same story. And there's also a footnote there too, where Subramanian essentially says if it was true that searching his cell was just an effort to obtain evidence against him, sure, that could be a Fourth Amendment violation. It would constitute that. There's case law to support that. But here, if you look at the record, there's nothing to suggest that that was the motive behind this search. But again, even if that was the case, again, for purposes of a Fourth Amendment violation, it's all moot, he argues, because the prosecution has agreed that they aren't using anything from that search in their case when this goes to trial in May. And for a Sixth Amendment analysis, the efforts made to protect Combs' privilege undermines the argument that there was some sort of intentional interference with the attorney-client relationship. So when it comes to Investigator 1, Subramanian concludes, far from an intentional prosecution-driven invasion into Combs' relationship with his attorneys, the record shows that Investigator 1 was doing his job as a BOP intelligence analyst and followed the established channels for reporting communications that pose safety concerns. The case team was informed of these communications when appropriate and similarly followed the established channels for obtaining information and protecting Combs' privilege. Care was taken to shield Combs' communications with his attorneys from the case team. None of this suggests that Investigator 1 deliberately set out to or was instructed to invade Combs' attorney-client relationship and impede his defense. Now, there is one final piece we got to talk about here. The prejudice argument. You remember I mentioned that? To see if there was a Sixth Amendment violation, it's not just if there was intentional interference, but was Combs prejudiced? Judge Subramanian again says no. He concludes that even if there was an intentional interference, unless you can show the government is absolutely corrupt, Combs has to show that this would unfairly bias the jury against him. It would unfairly taint the case against him. In other words, you have to show that violations of his attorney-client privilege ends up producing evidence at trial that will be used against him. But once again, the government promised it's not using the notes or anything that came from the notes in its case against Combs, again, when it goes to trial in May. And Subramanian says that because the government provided information about this investigation and this whole ordeal, both the court and the defense, they're already ready. They're ready to flag any suspect evidence attempted to be put forward by the prosecution that may go against their promise. They're ready to jump at the prosecution, so they're all aware now. As Subramanian writes, at this point in the case, the wholly conjectural connections that Combs draws between privileged information and the government's case, including general allegations of taint unconnected to any specific evidence to be presented at trial, are insufficient for a finding of prejudice. So what about a hearing, right? Should there be a hearing to resolve all this? Combs and his team had argued that we need to get a hearing to really get to the bottom of what Investigator 1 was up to. We should see his communications with prosecutors. He should have to testify. But Judge Subramanian concluded that none of that is necessary because he already ordered that such evidence and sworn statements be produced, and they were. In other words, the record is sufficient. Quote, here, the government provided a lengthy affidavit by a member of the case team based on her review of relevant communications and conversations with other members of the case team and supervisors from the U.S. Attorney's Office. Investigator 1 also submitted an affidavit. Together, these documents presented a clear, factual narrative, which Combs then had the opportunity to respond to. The court also had the benefit of an in-camera review of the government's communications with Investigator 1. With such an extensive paper record to rule on, no live hearing is needed. And also, Judge Subramanian addressed the other argument from the defense that they need a hearing to see whether any of the prosecution's evidence comes from the notes. It's a big issue we've been talking about. More specifically, the defense wants to know the extent to which the case team used the privileged notes to develop leads or uncover new evidence, or whether other information from Investigator 1 led the case team to develop new leads or gather new evidence, as opposed to, for example, the evidence coming from legitimate independent sources. This is the fruit of the poisonous tree issue again. But the problem, according to Subramanian, is that if you look at the case law on this, a defendant really needs to establish that connection between privileged information that was improperly obtained and the prosecution. And Subramanian writes, Combs doesn't come close to making such a showing, particularly now that the government has disavowed use of the notes or evidence derived from them. In other words, Combs is only speculating that the government's evidence is somehow tainted. He really hasn't shown how. Quote, the generic nature of the notes makes it unlikely that any improper use of the information has or could be made. They give Combs general thoughts on how to approach certain issues, none of which would come as a surprise. However, if a question arises closer to trial as to the use of suspect evidence and Combs can make a threshold showing that the evidence is tainted, then Combs can bring it to the court's attention. Until then, the government is cautioned to be mindful of Combs' privilege and the need to abide by filter team processes. While there is currently no demonstrated need for a special master, the court recommends that the filter team clear potential privileged documents with the defense before turning them over to the case team. So the judge kind of admonishing and also instructing what the prosecutors and the filter team need to do moving forward. And there you have it. Definitely not a win for Sean Combs. No violation of his rights. There's no hearing. And look, the government, they can't use the notes in their case, which if you read between the lines is potentially evidence that he was contacting a witness. That's the allegation. That's what it seems to be. Perhaps important for the tampering with witness allegations in the superseding indictment as part of the underlying racketeering charge. But that is a very broad charge. There's a lot the prosecution is going to put forward to prove that charge. So it doesn't appear, at least to me, that this specific point of potential evidence, what these notes would have presented for the prosecution, whatever benefit these notes would have had for the prosecution's case, I don't think that's necessarily going to, make or break the prosecution's case. So it doesn't seem to me to be a big loss to them. Interesting update. We'll continue to follow this case. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.